Welcome back. In the recent layoffs at Agoda, lawyers CNA spoke to say clauses in severance agreements that prevent employees from reporting layoffs to the authorities are not legally binding. They say it is deemed unlawful as it limits an employee's rights. An Agoda severance agreement seen by CNA detailed that employees should not report the layoffs to government agencies, unions, or statutory boards. CNA understands that around 50 staff in Singapore were laid off. One lawyer says such clauses are uncommon. He says that certain laws like the Employment Claims Tribunal Act are in place to protect employees.
As to why Agoda has chosen to put this into the severance agreement, I can't say for certain, but it could be out of an abundance of caution. For example, in cases where an employer has been quite generous in terms of the severance package offered to its employees, it could want to extract concessions that are more robust to ensure that there is no recourse that the employee will have after the agreement is signed.
However, Mr. Ding adds that the clause is effective in preventing employees from pursuing a civil court case.
The clause will be effective to prevent the employee from otherwise bringing a claim before the courts, for example, because that cause of action is a private right that the employee has, and that's not covered by the ECT Act.
And to help us understand the legal issues behind this, I'm joined by Tracy Tian, who is a consultant at the Singapore Human Resources Institute. Tracy, great to have you with us today.
Thank you for having me.
Let's start with the story that we heard earlier, where the reports say that there were clauses in Agoda's severance agreement that actually stop staff from going to the authorities. From an HR and also a legal perspective, is this fair? And also, should it be allowed?
Well, it is definitely unusual to see such clauses. Within Singapore's strong tripartite frameworks, such measures are actually unnecessary and not in line with the fair and progressive HR practices. So we would say that, yes, it's really quite unusual, and at SHRI, we encourage all companies to approach retrenchment exercises like these with a lot of empathy and a lot of transparency.
And in this case, if someone is faced with an employment contract or a severance agreement like that, what should they do? Is it safe to just sign it, or can they push back on it?
Well, I think we would always encourage employees to certainly take a pause, consider carefully before proceeding. And if there are certain clauses that are contrary to those guidelines, as mentioned, they can seek and consult MOM and unions for a viewpoint before they proceed. Yeah.
Right. And in this case also, when they are signing, it does put some pressure as well on them to just sign. But is there any precaution they can take in this case with the employer, which would have the power position in this case?
Well, in Singapore, I would probably think in terms of the information and the data points that we have, a lot of employers are actually very open to clarifying some of these terms, especially when they're raised. And that's where employers get that clarity. And when they weigh the options, they will then know, okay, what's the position they're going to be taking, and they can then proceed from there.
And then for those who have already signed, for example, on those restrictive terms, what kind of protection do they have?
Well, in terms of these protection, I would probably say that when it comes to the tripartite system in Singapore, the design of the system is such that it protects employees from unfair terms. So when we look from that standpoint, it's really important that employees have that viewpoint first before they continue with the next course of actions. And always know, I think, what we're trying to reiterate and put forth, to affected workers and even workers today is that they need to know that they are not left without support.
And speaking of that support as well, if you've already read through thoroughly and also that you've done enough to check, or rather if you haven't, then is there a recourse for people who have already signed and they haven't checked?
Well, this is, I would There isn't a one-size-fits-all answer, but I would think that every employee who has been in such a difficult situation, they would definitely have weighed their options before they proceeded. Again, I just want to come back to the point where, it's important to just pause, seek consultation with MOM unions, and then have a certain position before they move forward. Yeah, because if some of these agreements, if they do rush into it and they sign on it, it may be a bit difficult, to come around with a secondary or corrective action from that standpoint.
Yeah, and speaking of preventing those corrective actions, right, are there other clauses, right, before people sign on to a company in the contract that they should be more mindful of that maybe not many people are?
Certainly. These other clauses actually would come in the form of confidentiality clauses, even non-compete clauses beyond just the severance payouts. So it's really, you have to have, I think we encourage a lot of these workers to have that mindfulness in terms of being aware of, the impact of these clauses and what they mean, because they may want to switch from one sector to the other or one company to the other company within the same sector. And, that sort of may restrict their career pathway from that, yeah.
Now, looking also at the impact that these restrictive clauses have, how does that affect trust on the part of the employees towards their employers?
Well, we see two main scenarios, or rather two different buckets. In one where such clauses are not so restrictive, and it's something that we encourage, back to the point where companies, we encourage them to emphasize a lot on transparency, a lot on empathy. It helps to foster that environment where employees feel safe, respected, and supported. But in the other bucket, where the overly restrictive clauses come into play, it creates that adverse effect on psychological safety. And when that comes in, then morale and loyalty will suffer. So it's really on two different spectrums, on the two different ends of the spectrum.
Now, Tracy, when you look at this case here, right, and similar cases like this, when there are restrictive clauses in these agreements, what does it tell us about HR standards in Singapore? What do you think can be done to also prevent such incidents from happening?
It's interesting you ask. SHRI will actually be holding the Singapore HR Awards next week. And from the nominations that have come through, we see many outstanding HR initiatives and policies that are put forth from SMEs and MNCs. So this goes to show that while there are areas we strive to always improve on, the HR standards in Singapore are not that weak. Yeah, so that's very encouraging, and it's something that, together with other partners in our HR ecosystem, the likes of HCLI, IHRP, and SNEF, SHRI endeavours to always strengthen and uplift HR practices in Singapore to better support both the business leaders and workers.
It's quite heartening to hear there are also people who are being recognised for good practices as well. Now, beyond the severance payouts, when it comes to retrenchment, it is a very sensitive time for many of the employees who are being retrenched. So in this case, how else can HR support staff through this time?
We would like, and we encourage companies to look at retrenchment as a last resort. And prior to that last resort, perhaps consider, can some of these jobs in the identified functions, can they be redesigned? Can the employees be reskilled? Can they be upskilled? And from a business lens, are there other areas where expenses can be reduced, right? So HR can then also make a difference in terms of like a career transition support to affected workers. It can come in the form of like a job placement assistance, or even connecting these affected employees with support networks. So these sort of actions then demonstrate that empathy, and it gives workers overall that confidence to move on, which we think, from the Institute's standpoint, is really, really important.
Yeah, well, before we go, Tracy, can you tell us a bit if you have any tips for people who are going through a bit of a tricky time with restrictive clauses in agreements? Anything you'd like them to take away in terms of how they can protect themselves and also support themselves through this time?
Well, always know that a lot of the support within our HR ecosystem is here. It can be MOM, it can be the unions, it can be HRI and some of our ecosystem partners. It's always good to be aware of the legislations, and also be aware that in today's disruptive world, sure, there may be certain unexpected difficult situations one will need to walk through, but not hold it to the point where it stops one's curiosity, one's learning abilities, and always look forward to, okay, if maybe an opportunity does close somewhere, have that longitudinal view to say there will be something else that will allow that person to continue that, their career aspirations and so on and so forth.
Continuing
so it's not
to
the
stay
end.
open in that
Yes,
sense. Yeah.
it's not the end. Yeah.
Tracy, thank you so much for sharing your perspectives with us. I've been speaking with Tracy Tian, who is an HR consultant from Singapore Human Resources Institute.